Good morning, and welcome to our webinar, HR and the Families First Coronavirus Response Act, What Employers and Employees Need to Know. Thank you all for joining us, and please continue sharing your recommendations for programs at communications@architects.org. We'll share this contact information again at the end of the program. I'm Eric White, Executive Director of the BSA. And before we begin, I want to share a quick update on some of the things that the BSA is continuing to work on to support you during this challenging time. First, Resources at architects.org has a collection of local and national resources that aim at helping you. I especially want to call attention to the firm's Best Practices Guide to COVID-19 that was organized by a task force led by BSA President Natasha Espada, AIA. It's a great resource that will continue to update as time goes on. Next, as you know, we're continuing these webinars that we're aiming to do 2 a week. And in addition, our knowledge communities have become coming back for their monthly meetings on virtual platforms. We will look forward to bringing these active communities back online, and we hope that you'll join them from your homes. Third, BSA Connect is a LinkedIn forum that we welcome you to join. It's meant to be a place where you can pose questions, share and find community outside of the knowledge community meetings and other BSA programs. You can find that by searching for BSA Connect on LinkedIn. We are also, as you know, helping to identify potential facility locations for the state to set up in response to COVID-19 that can include emergency healthcare and as well as isolation areas. And for more information on that, visit our website at architects.org. Our next webinar is Monday at 1 o'clock and is a practical guide to the CARES Act for architecture firms. The presenters will be Stephen E. Minson and Rick Strout from DeChico Goldman and Company. Now, while we continue to put on programming that supports all of you and beyond Boston, I'd like to mention that this is an opportunity to sponsor such programs. They are addressing the issues of today and serving the AEC industry while reaching hundreds with each session. And now let's start with this session on HR and Families First Coronavirus Act. Before we begin, just a few rules. Because we have such a large number of participants, you will all be on mute. For our question and answer period, we have selected a number of questions that were submitted ahead of time, and thank you for sharing these. And though we will not be able to address all the questions, we encourage you to continue to share these as they are helping us identify future programs. Otherwise, and in addition, you can use the Q&A link at the bottom of the page. This session will be recorded and posted on the COVID-19 resource page on architects.org early next week. And now, I'm excited to introduce our speakers. Lindsay Burke is a director at Kenney Sams and defends and asserts the rights of companies entangled in complex disputes. Her cases often involve business-to-business contract disputes, business divorce, trade secret litigation, non-competition agreements, and questions regarding intellectual property ownership. And Michelle de Oliveira is an associate at Kenney Sams and a litigator who handles, among other things, employment-related disputes. This includes, but is not limited to, wage and hour, leave entitlements, disciplinary actions, internal investigations, restrictive covenants, discrimination and harassment matters, as well as drafting of employment policies and contracts. And so, without further ado, let me turn it over to Lindsay and Michelle. Thank you.
Thank you very much. This is Lindsay Burke. I hope that you can hear me. I'm having a little bit of trouble. I'm not allowed to start the video right now, but if you can hear me, maybe we can get that worked out. And in the meantime, we can go ahead and get started just talking through some of this stuff until I can join you by video. But
and Lindsay, we can hear you, just so you know.
Okay, that's terrific. So we wanted to take a moment to talk with all of you, and thank you so much for being here with us today. We wanted to take a moment to go over some important new laws that are coming into effect that are going to be affecting really every workplace in the country for the rest of this year at least. And so what we wanted to talk about are some new emergency leave laws, which are applying to all employers under 500 people. And if your company falls under that threshold of 500 employees, these are new emergency leave laws that apply to you. So we're going to talk about what those laws contain. The the FFCRA is the Families First Coronavirus Response Act. So that's the sort of umbrella term for what we're going to be talking about today. We're going to go over, oh, hello, there's the video. Hi, everyone. So we're going to be going over a summary of the FFCRA, what employers should know. If you're on the employee side of things, what you should know in terms of what your rights are under these rules. We're going to briefly go over some unemployment benefits because the unemployment landscape has changed significantly as well. We especially, I'm sure everybody's seen the news. Unemployment has become really a lifeline for millions and millions of people. The filings in the past 2 weeks have been 10 million filings, which is even more than the entire 2008 recession, which lasted over 18 months. The number of people that have applied in the past 2 weeks dwarfs that entire 18-month period. So we're really in unprecedented times. And a lot of the employer clients that Michelle and I counsel are very interested in the unemployment side of things because they want to do what's right for their people. They want to make sure that their team members who they, unfortunately might be having to let go because of the downturn have options and what their options might be. We're going to go over the Q&A. We got some terrific questions submitted and are really happy to be going over some of these topics with you. And, we'll kind of wrap it up with some takeaways. Okay, so here's the general overview. In a nutshell, there are two components of the leave. One, the longer term one, is for people in your organizations who have children at home, children under age 18, whose school is closed or whose daycare is closed, and that they need to be home. They can't come to work because all of a sudden they have this childcare need. We're seeing this a lot in particular. I mean, as we all know, the schools in Massachusetts have closed. All across the country, schools have closed. I saw a figure yesterday that said something like 87% of the world's children are not in school right now. So this affects everyone who has children under age 18. 10 weeks of paid leave to care for a child under age 18. So we'll go over some of the details of that in terms of how much pay and what triggers it and what you can ask for and all those kinds of things. But that's one extremely expanded component of this new emergency leave. The second is for the illness side of things. So setting aside the childcare side of things, if you have an employee who is sick or who is caring for someone who is sick or who is quarantined or who is symptomatic, there's 80 hours of paid medical leave, so 2 weeks paid leave, on top of whatever health benefits you're already offering. So it's an additional 80 hours of paid leave under those circumstances. Okay, so this is a big chart. And the reason that we have all of these kind of details up here for you is that this is, it's a little bit tricky in terms of who applies for what reason and what category and how many hours they get, if they fall into these different categories. So we wanted to make sure that you had all of this in one place. The Department of Labor also issued a poster that should be posted in your workplaces or shared with your employees in some way if you don't have people working, physically on site, which many of you I'm sure do not. That lists all of this information as well. You can get that on the Department of Labor's website, which is kind of a good distillation of what all of this means. But Michelle, do you want to cover the family and medical leave piece of it?
Yes. So thank you everyone for joining. It's a pleasure to be here speaking with all of you. I will talk briefly about Division C here, which is the first section of the chart. So this is the section of the statute that applies to folks who need to be out of work because they have a child who's out of school due to a school closure or lack of childcare because the childcare provider is unavailable for a COVID-19 related reason. In order to be covered under this section of the statute, the individual must have been employed for at least 30 days before taking the leave. So that is important, and that 30-day period will count as of the date the leave is requested, and then you go backwards 30 days. So long as the individual was employed, he or she would be covered. So the first 10 days of the leave under this section will be unpaid, and the remainder 10 weeks of leave thereafter will be paid. During that initial 10-day unpaid period, if the employee wants, the employee can use PTO, sick leave, or vacation to cover up that 10-day unpaid period so that the employee can get paid. The pay rate is 2/3 of the employee's regular rate of pay. The calculation is based on the number of hours the employee would otherwise be scheduled to work during that 2-week period, and we're going to talk a little bit more about that later on. There's a maximum and minimum about what the employee needs to be paid per day. So the maximum is $200 per day, and in total, the employee can only get $10,000 in the aggregate total paid leave. The duration is both for both of these, both sections of the statute. It's a maximum 12 weeks period that the employee would be entitled to if he's eligible, he or she is eligible, and if the employee does not elect an exemption, which we'll talk about later on as well.
Great, so I'll cover this Division E, which is the right-hand side of the chart. So this is for the paid leave, which is, what we were talking about before. This is the situation apart from when someone is taking care of a child. This is if they are in one of these 6 categories. So the first is that they are subject to a federal, state, or local quarantine or isolation order. We interpret that to apply to, say, for example, Governor Baker has said that if you are coming into Massachusetts from out of state, if you've been, anywhere else, they're asking you to self-quarantine for 14 days. So that would apply to someone in that situation. Someone who has been advised by a healthcare provider to self-quarantine due to concerns. This is one we're seeing a lot. A lot of employees are falling into this category because they are they're calling their doctor and saying, I got coffee with my brother and then he was tested positive. What should I do? And the doctor is saying you should stay home for 2 weeks. Some are sort of self-quarantining on their own. Some employees are just saying, I know that, my spouse was exposed to someone, or there was a case in my, child's school last week or something like that. And they're kind of self-quarantining. That likely wouldn't fall into this category, but it also would be extremely easy for them to get a note from their doctor to say that that is the correct thing to do. So I don't think we're going to have, I don't think that sort of push, if people are self-quarantining in this way, the fact that they're doing it on their own instead of a doctor telling them to is probably not going to be reason to deny them leave for this. The third category is that they are experiencing symptoms and they're seeking a medical diagnosis. This is something that's, generally good practice anyway, that if you have any employees who are symptomatic, and I don't know how many of you are still having anyone come to the office. My suspicion is most people are working remotely at this point. For some people who are, working, supporting essential services, some construction I know is allowed to go on. So I'm not sure if you have people that are working on various projects that might be continuing to work, physically in person. But if they are symptomatic, they should be being sent home anyway. This is applying more to can they get paid while they're out? And if they are experiencing symptoms, and the symptoms are fever, dry cough, fatigue, and they're seeking a medical diagnosis. So we all know, I think, that the testing has been difficult to obtain. It's not everybody falls into a category that will allow them to get a test, even if they are experiencing these symptoms. And unfortunately, we're also learning that these tests have a very high false negative rate. So there might be someone who is symptomatic of COVID-19, but has gotten a negative test result. I would put that person in this category still, that if they are symptomatic, they would fall into this category 3 of being entitled to paid leave. So those are the sort of, the employee personally is experiencing something COVID related. The sort of, the next column over here, items 4, 5, and 6, these are reimbursed at a lower rate. I'll go down the chart to talk about that too. One is that the employee is caring for someone who's in quarantine or who's been advised to self-quarantine. So if you have an employee, for example, whose child has been told to stay home, or who has an elderly parent or aunt or uncle in the home that they need to take care of because that person can't, leave the house to get groceries or go to their doctor's appointments or whatever, needs someone to help them with that because they're elderly or immunocompromised or asthmatic, et cetera, then the employee is entitled to paid leave to do that, to take care of that person. Next is the school closure, which again, this overlaps with the other leave that Michelle was just talking about. So you'll see that there's a little bit of overlap here. And then category 6 is kind of a big question mark. This one is the employee is experiencing any other condition substantially similar to COVID-19. Then you'll see that the Department of Health and Human Services is supposed to specify what that means. They have not done so. So we don't know what that condition substantially similar means. And I've been advising clients in the absence of guidance on this, that if anybody has the symptoms, I bump them into that category 3 and say, okay, if they're symptomatic, even if it's maybe a little bit different, maybe their fever's not quite as high, or maybe the cough isn't really a dry cough, or, we're all kind of guessing what this condition substantially similar means. So if they're symptomatic at all, I would put them in that category 3 and, be entitled to that leave. So the leave is for full-time employees, 80 hours of paid leave. If they're salaried, it's 2 weeks pay. It's 2 weeks is the goal for this leave for full-time employees. For part-time employees, how many hours average have they worked over a 2-week period? So you're gonna, have to take those on a case-by-case basis. And then the pay rate, this is where the division is. So if they are in these categories 1, 2, and 3, meaning they're personally experiencing something, quarantine, symptoms, etc., they get paid at 100% of their pay rate with a cap of $511 per day. And then if they are in these categories 4, 5, and 6, and as I said before, category 6, we don't think really means anything right now, but basically they're taking care of someone else. This is I have an elderly person in the home, or I have an asthmatic child in the home situation. They get 2/3 of their pay with a cap of $200 per day, $2,000 in the aggregate. So really the reason that we sort of give you all of this detail, and that I commend that Department of Labor poster to you, is that you're going to need to take each employee's situation on a case-by-case basis, and sit down with them and figure out, okay, why do they need leave? Which bucket do they fall into? And how do I do the math to calculate their pay based on that analysis?
So now we're going to jump into the next section of the program, where we're going to be talking about things that are important for employers to know when they are dealing with employees who come to them with questions or leave-related needs. So we've picked out 11 things that are important. I will say that, this law keeps evolving. The DOL has been issuing guidance on this law continuously. So this information is based on what's out there so far. We do know that a final rule is going to be published, according to the Department of Labor, on April 6th. A temporary rule has already been published, and we don't know if anything is going to be changed from now until the 6th. So, more information to come. So let's start with number 1. A lot of folks, when this law was initially passed a couple weeks ago, were asking whether or not the statute would apply retroactively, because COVID-19 has been, impacting the workplace for a bit now, and some people had already been out before the April 1 effective date of the statute. We now know the answer to that question, and the answer is no. So it is not applied retroactively, and is only to be applied prospectively from the effective date of the statute, and it's going to be in effect through December 31. So we know that the Families First Coronavirus Response Act is an amendment to the existing FMLA. So some employers were already providing FMLA leave to employees if they employed at least 50 or more employees. So for those folks who were already providing FMLA leave, It's important to know that the total leave that you will need to provide to employees is still going to be 12 weeks. When you're taking the FFCRA and the FMLA, it's a total of 12 weeks. So if you already had an employee take a leave related to the FMLA, you can count that time toward that 12-week maximum period if an FFCRA related need comes up. Now the big question is, number 3, what employees should an employer count toward that 500 employee threshold? The reason this is important is that we know that the FFCRA applies to employers who have fewer than 500 employees. So it's important for employers to be able to know who counts. So we know that employees on leave count. The DOL has clarified that. We also know that temporary employees count and day laborers count. Now this is in addition to employees who are on your normal payroll, part-time and full-time employees. But if you have temporary employees, employees on leave, and day laborers, those count. Independent contractors, however, do not count. So if you have an independent contractor who works with you in any capacity, so long as that individual is properly classified as an independent contractor, you do not need to count that individual toward the 500 employee threshold. There are situations that may come into play when you're dealing with either the integrated or joint employer relationship. So if that ever comes up, it's a situation that companies need to assess on a case-by-case basis. Now, number 4, another question that has come up repeatedly is whether leave entitlements under the FFCRA will be running concurrently with other forms of leave. Specifically in Massachusetts, we have the Earned Sick Time Leave Law. And so a question was, do I need to provide leave under the FFCRA on top of what I already need to provide under the state sick time law, which is 40 hours of sick time per benefit year? The answer to that is no, it does not run concurrently, and the benefit is an additional benefit on top of what is already provided. For number 5, whether an employee can supplement the employee's pay while out on FFCRA leave, the answer to that is yes. So although the leaves do not run concurrently, and although it is an additional benefit, if you have an employee who is receiving 2/3 of his regular rate of pay while out on FFCRA leave, it is possible if the employer agrees, it's not required, so if the employer and the employee agree to have that pay supplemented so that the employee receives 100% of his or her pay while on leave, that is possible. The key for employers to know is if an employer does that, the employer will not get an additional tax credit for that difference, right? So the tax credit piece, which Lindsay will talk about later, only applies to pay that is required under the statute. So an employer can be more generous if the employer wants, but there will not be additional tax credit for that increased pay.
I just want to jump in, Michelle, because we have a couple of questions on the Q&A. So I'll read them out loud in case people don't have that chat up. But the first question was about, what about for a self-employed one single person office in case that gets impacted? So there's certainly, if there's one self-employed person, you're entitled to this leave. There's no requirement that that you not be the owner of your own business. Then it's really just a business decision, I suppose, of how you want to do the paperwork in terms of the time that you're taking to either deal with your childcare responsibilities or being ill or quarantined. So the legal answer is that there is no restriction on that. You can certainly take the leave as the owner of the company, but it just might be a matter of how you decide to do the math and document it through payroll, et cetera. Do you want to add anything to that, Michelle?
No.
Okay. Okay. Go ahead, Michelle. Can you take that second one?
Yeah. So the second one, the second question is whether the first 10 days based on, I think it's a pay rate. I think the question is whether the first 10 days that's unpaid, how that time is tracked, and then what the employee can do, if the employee wants to take certain hours of leave per day as opposed to taking leave consecutively. We're going to touch on that issue. That's going to trigger the topic of intermittent leave. So I think we can reserve that to be discussed in a bit, but we will address it. All right, so let's talk about part-time employees, right? So the key here is that the leave is going to be paid out in accordance with what that employee's regular rate of pay is, and in accordance with what that employee would otherwise have been scheduled to work, right? So then the question is, okay, so if I have a part-time employee, how do I count the hours that that part-time employee works? And the answer to that is it depends. It's going to depend on whether that employee is on a fixed schedule or whether that employee is on either a varying schedule or the hours are unknown. And we'll talk about those situations and how an employer should address that. So if it's a fixed schedule, then it's going to be the easier scenario, right? So an employee who's on a fixed schedule will be entitled to leave based on the hours that the employee worked during the last 2-week period. So if the employee is going to be out, this is under the Emergency Paid Leave Act, which I should have mentioned initially. So it will be based on what those hours would be, and you calculate it based on that. Now, it's different if somebody's on a varying schedule or if the hours are unknown. In those circumstances, the employer has two options. If the employee has been employed for at least 6 months with the employer, then the employer can use the last 6 months to calculate what that employee received in total, and then you divide it so that you reach the average pay that the employee received per day, right? So you take the last 6 months, you figure out how much that employee worked in total in those 6 months, and then you calculate the average per day, and then that per day calculation you can use to determine how, what that employee will be paid. So that's option one. If the employee has not yet been employed for 6 months with the employer, then what the employer needs to do is take the total amount that the employee has worked, right, from day one until the time of the leave. You take that total amount and then you calculate the average to figure out, what that employee's daily pay has been over the course of the employee's employment, and then you use that number to figure out, what the hours the employee has worked and how much time that employee is entitled to be paid for during the leave. All right, so we can move ahead now to question number 7. So overtime is also a question, right? Because what if somebody works overtime? Does an employer need to count that overtime when the employer is calculating the hours that need to be paid out? So let's talk about the emergency paid leave portion of the statute. And this is the portion of the statute that deals with folks who are either sick themselves or caring for somebody who is sick. And it's on the chart, Division E of the chart that we provided on an earlier slide. So under that portion of the statute, the employee is entitled to 80 hours of paid leave in a 2-week period, right? So in total, that's what the employee is entitled to receive. So let's say the employee was scheduled to work 50 hours on week 1, 30 hours on week 2. It would be a total of 80. That those 50 hours for week 1 would count. The bottom line, what's important is that it's up to 80 hours of paid leave in a 2-week period. So the employer is looking at a 2-week period mark. What about under the other section of the statute that deals with folks who need to be out on leave because a child is out of school due to a school closure or due to lack of childcare? So under this portion of the statute, the employer needs to include overtime when calculating pay if and only if the employee was normally scheduled to work more than 40 hours in a week. The reason for that is that under the statute, that the pay that the employee is entitled to receive is supposed to be based on the number of hours the employee would otherwise normally be scheduled to work. But even though the employer is calculating those additional hours, there's no need to include premium pay for overtime. All that the employer is doing is tracking the total number of hours and paying it in accordance with that. Now, regular rate of pay. So again, we've been using this term, right? Regular rate of pay. It's number 8 there on the slide. And then the question is, how does an employer know what the regular rate of pay is? Again, we're going to be looking at how long the employee has been with the company, right? It should be for somebody who's been employed for at least 6 months. The employer needs to look at the average of the employee's rate over that 6-month period, right? So you look at the average that the employee worked over a 6-month period, and depending on how many hours that employee worked over the course of the 6 months, you calculate it to come up with the average that the person received, and then you use that number as the employee's regular rate of pay. Of course, this is tricky in cases of hourly employees. If you have exempt employees, doing those calculations might be a little bit easier. Importantly here, when an employer is calculating the regular rate of pay, you need to include commissions and tips in that calculation as well. So it's not only the hourly rate that needs to be counted. Now, if employees have been working for less than 6 months, then the employer needs to do the same thing. The employer would be looking at the total amount of time that employee has been employed with a company, and then you calculate the total amount the employee earned, and then you do the calculation so that you come up with the daily rate that the person received, and then you can come up with the hourly rate as well. Now we're going to talk about, now I'm going to transfer it over to Lindsay to talk about intermittent leave and tax credits.
Okay, so we have a couple of questions about this too, which is before I move on to intermittent leave, we just got a question about commissions and tips and bonuses. So I want to make sure we cover that before we move on. So Michelle, can you address that about how do bonuses factor into determining the regular rate of pay?
Yes, so the DOL guidance has not touched on the issue of bonuses. And I think, right, the reason is that a bonus is not considered a wage in most states, I would think. And that could be a reason, we don't know. But right now, the DOL guidance is focused on commissions and tips. So as of right now, the answer is, if we get a question about whether or not bonuses are included, I think the safe answer right now is that no, bonuses are not included. And I think that is also tied to discretion, right? So an employer, oftentimes bonuses are tied to discretion. An employer can either give a bonus or not give a bonus. And I think because it's so fluid, that is probably why it's not included. We can look at once the DOL publishes the final rule, that might change, but I don't think so. So only limited to commissions and tips.
Okay, great. So the next topic is this intermittent leave, and we certainly are experiencing. So many of us are working remotely. So there's certainly, in businesses who have shut down their brick and mortar locations, have been encouraged to allow employees to telework as much as possible, as much as things can be done remotely, that they should be done remotely. And so many of us are continuing our work lives from home, and for folks that are on salary, exempt employees, it's quite possible that you are not, and it doesn't really matter if their workday has been compressed or they're being more efficient, or maybe just unable to just put in the same sort of 9-to-5 workday that they were doing before. But if so for those folks, it might not matter as much. But you might have people who are teleworking but not able to put in a full day. And so, their experience, and they're hourly folks. And so, how do you figure that out? They're working from home, but they maybe have childcare responsibilities for part of the day. So, it's something that we really encourage people to talk with their employees about, figure out sort of what's a reasonable schedule and how are you going to track the time, because employers still have the responsibility to track people's time. Whether they're teleworking or not. So that's a challenge for people who typically have timesheets or people punching in and out, et cetera, and now they're working remotely. So the issue then is what do you do with people who want to take sort of this intermittent leave? Now, under the FMLA, the Family Medical Leave Act, typically employees can take it in segments. It doesn't have to be a full day at a time. And as I mentioned with the childcare piece of it, it's quite possible that you'll have employees that want to do the same thing with the childcare leave portion of this, if they have help for some of the day, but not the rest of the day. For the sick leave, we're not seeing that because if people are sick, they're sick, they're really sick and they're not working at all. So we're not seeing much intermittent leave for individuals who are suffering from coronavirus. Again, if it's a caregiving portion of the leave, that might be more likely to see that. So Michelle, do you have anything to add to that?
The only thing that I'll add is that under the DOL guidance, if the employee is out because the employee is sick, or caring for somebody who is sick, intermittent leave is not allowed. So the employer cannot offer it, the employee cannot get it. That's the only thing that I'll add. And actually, no, I'll add one more thing, that under the DOL guidance, the DOL is encouraging employers and employees to come to an agreement, to just sort of make things work out so that employees are able to keep their jobs while not exposing folks in the workplace to potential COVID-19 and being able to stay home and care for their children. So there is an emphasis on employees and employers working together to come to a mutual agreement.
Right. And part of the reason for this is they really sort of the underlying public policy for many of these rules is they really don't want sick people going to work at all. And for many people, this is a financial decision. This is disastrous for them if they're not working. And so they are, especially earlier on in the crisis, we had people going to work sick or exposed. And obviously the spread has increased because of that. So that's generally when you're thinking about, okay, well, why is it different for childcare versus for people who are ill? That's generally the public policy reason is we do not want any incentive for employees to be coming to work sick or symptomatic. Tax credit. So how do you pay for all of this? The government has put this responsibility on employers to provide this leave, and on employers under 500 employees are often, don't have vast reserves of cash to pay these things out. And also everybody's experiencing a downturn right now. Jobs are stopping, the phone's not ringing as much. And so how do you pay for this? The idea is that this is going to be 100% offset by payroll tax credits. That piece of this program has been in flux. And so the guidance has shifted on it. As lawyers, we often, our job is to give clients the right answer to questions. This has been such an interesting time because there are things we just don't know, and because it is not yet clear from the government in terms of how this is going to work. So this is one that has changed, because originally it was going to be that the way the tax credit was going to work is you paid your payroll taxes the way that you always do, and then you get a refund to offset your costs for, paying for this emergency leave that is new for people. Quickly that changed because I think a lot of businesses were saying, we can't front this money for that long and have to wait for a tax credit. We're going to go under. And so they have made it so that the employer can deduct it themselves. Michelle and I are not accountants, so I wouldn't presume to give you advice in terms of the IRS forms that you need and the actual, the way that you document it. We are encouraging employers to keep really good records of who is taking this leave, what their rate of pay was, so that we can make sure that you have the documents that you need to justify this tax credit, but you should talk to your accountants about the mechanics of how to make sure that you're getting it. So it's 100% qualified wages for each calendar quarter through 2020. Again, all of this sunsets after December 31st, 2020, with the hope that this is all past us. It is, credits will be increased to include your contributions to employees' health plan coverage. Again, public policy is we don't want anybody being kicked off their health insurance right now. We need it. And then if you are giving more than what the FCRA requires, you don't get additional tax credit for going beyond. All right, so let's move on to the next slide.
So now we'll talk about the small business exemption, right? So a lot of employers have questions about this, and the question is understandable, right? Because this could put a burden on employers for paying out paid leave at a time where the economy is not doing so well, at a time where jobs are shut down, at a time when money can be short for certain employers, right? So what happens, there is a carve out in the statute for small business, right? Small businesses. What is a small business? It's any business with fewer than 50 employees. Initially, when the statute was enacted, and the language in the statute itself had language that a small business with fewer than 50 employees would be able to elect an exemption so that the business would not need to pay out sick leave under the FFCRA. And so now, since the publication of the DOL's temporary rule, we have some additional guidance and insight on this. According to the DOL,
we've lost the presentation, but that's okay. We're going to move on to the things that the employees need to know. And so I'm going to speed up a little bit because I think most of our audience here is HR professionals and people that are running businesses, but I want to talk a little bit about the employee side of things. So we'll just go on. Great, thank you. Great. So the employers cannot force the use of other leaves, PTO or vacation time, before you are entitled to take these protected leaves. So you can't, now, for the childcare piece of it, and we have a question on this, I wanted to address that too. The first 2 weeks of the 12-week childcare leave is unpaid, and the employee may use vacation time to offset those losses during that time. And then the 2/3 pay picks up in week 3. So they can use, if they have unpaid paid time or accrued and unused paid time off, vacation time, they can use that for the first 2 weeks, but you can't make them. They're entitled to the leave immediately. One of the questions that we have is, this question says that they have an employee who wants to take 2 hours a day for childcare. So say 10 hours a week. And then, but with the childcare being a 12-week program, do they have to wait 8 weeks in to exhaust that first 80 hours of leave? Michelle, I'm curious about your thoughts on this too. That's a new one for me. My advice would be have them use vacation time or PTO time if they have it for those first 2 weeks, because otherwise the goal is certainly not to make people be unpaid for the first 8 weeks of the program. But if they're doing it on this intermittent basis, it just gets a little bit complicated. When does that 2/3 pay kick in? So it's a really good question. But if this employee, I think it's a she, wants to take some PTO for that first 2-week period and then bump right into the 2/3 pay in week 3, I think that would be the right way to handle it. Michelle, what do you think?
Yeah, no, I absolutely agree. And then the only thing that I'll add is if, once that 2-week period ends and then that 3rd week period kicks in where the employer would be entitled to pay, aside for an exception, if that employee wants to take the leave intermittently, then it would require a discussion with the employer to figure out whether that is something that the employer will allow the employee to do based on the job.
Yeah. So I hope that answers it. Feel free to ask for more clarification if you need it. So job restoration, typically when you take any FMLA leave, your job is protected while you're out and you're not to be retaliated against. You can come back. Here, there is an exception for very small businesses under 25 employees who just the job has been eliminated because of COVID. So if it's just, you would have been laid off during that time anyway, you're not going to be, they don't have to create a position you don't have to create a position for this employee to come back if they were going to be part of a layoff anyway during this leave. It's just, their job's just gone. So, but typically you would restore the employee back to their position once this leave was over, again, hoping that there's a job for them to come back to. Their health insurance should continue during the leave. Again, always err on the side of continuing people's health insurance if you can. I'm going to skip the business shutdown piece, but what if I need leave for multiple purposes? This is a little complicated, but Michelle was talking earlier about this 12-week cap. You're just not going to go beyond that. So you can't. So if you have both symptoms and you're taking care of a child, you are still subject to that 12 weeks. You don't get the 80 hours and then your 12 weeks starts. And that's true also if you get sick, maybe more than once. Maybe you're taking your 80 hours because you're taking care of a loved one who is ill or quarantined, and then you get sick. You don't get another 80 hours paid if you've already exhausted it. So it's going to be, that you basically get it once. Let's move to the next one. Thanks. What if my employer doesn't allow me to go out? There is a complaint process that this is going to be enforced the same way that all sort of leave retaliation is enforced by the government. They're going to be investigating these kinds of things. There's a complaint procedure, and your employer I would hope this doesn't happen, but that there are Attorney General. You can complain to the Attorney General's office, and there's complaints procedure for this to go through. What documents do I need to give my employer? So the new law didn't specify what kind of documentation. This is a question we get a lot of, what can I ask for? Typically, if somebody needs FMLA leave, they need to provide some documentation from their doctor saying, yes, this patient needs FMLA leave and they need this much of it. They don't need to specify exactly what's wrong with the patient. There's still privacy concerns, et cetera. But you can ask for a doctor's note, essentially, if they're taking leave. If it's for childcare, certainly they could provide you with something saying that school is shut down. I've been telling employers, we all read the paper. I think it's kind of unnecessary to ask for documentation that your child's school is closed when we all know that the schools are all closed. They could just give you the Boston Globe probably, but you could ask for certification of that. If the company shuts down or your hours are reduced, now we're talking about unemployment. We're going to talk about unemployment a little bit later. So because that's really what your options are if your company shuts down and your role is eliminated, or you're furloughed, which is the reduction in your hours. Company I work for has fewer than 500 employees. Am I entitled to the leave? Yes, unless they fall into that under 50 hardship category that Michelle talked about before with the exemption. And if you need more than 12 weeks of leave, unfortunately, we're getting into unpaid leave territory. So that's what would happen after 12 weeks.
Now, we can move on to the next section. And in a nutshell, so there are new emergency regulations that were enacted to address unemployment benefits in the midst of the COVID-19 pandemic. The regulations are effective March 1 through June 1 of this year. The 1 week wait period during which an employee would typically need to wait to get unemployment benefits has been waived, and the requirement that individuals actively search for work during the unemployment period has also been waived. Couple of things an employee needs to do in order to, once the employee applies for unemployment benefits, the employee needs to maintain contact with the employer, and the employee needs to be available for all hours of suitable work that the employer offers during that unemployment period. The employer also needs to submit verification to the Department of Labor, to the Division of Unemployment, to notify that the employee is in fact in standby status, has a return to work date, and is out but because of COVID-19. It's 4 weeks of benefit, which is the default. The max is 8 weeks, and the DOA has discretion to extend it if needed. So that's unemployment benefits in a nutshell. I think we can move on now to the questions.
So we have a few more questions in the chat that we have some questions that we've prepared ahead of time based on submissions as people registered for this webinar. We have a few in the Q&A as well. So one is, what are the conditions that an employer needs to comply for a small business with less than 50 exemption? Michelle, do you want to just clarify a little bit of what we know so far of how to get that exemption?
Yes, absolutely. And I'm sorry about that. I think we were offline for a few seconds there when we were talking about that. So there's 3 criteria. The employer needs to determine that its expenses and financial obligations would exceed the available business revenue that the employer is taking in, and therefore it would impact the business operations, right? So the employer would need to document that, maintain records for 4 years. That's the first criteria. The second criteria is that if an employee's absence because of that paid leave would create a substantial risk of financial health or operational capabilities of the business because that employee's specialized skills, knowledge of the business or responsibilities. In other words, if the employer were to grant leave to this employee who needs, who asks for the leave, it would impact the business because of that employee's specialized skills and knowledge of the business. And then the third criteria is that there aren't sufficient workers who are able, willing, and qualified, and who are available at the time to perform the work that that employee who is requesting leave needs. So in other words, if an employee comes to the employer and says, I need leave under the FFCRA to care for a child who's out of school due to a school closure, a small business with fewer than 50 employees may be able to elect an exemption if the employer is able to show any one of these criteria. It's not an and, it's an or. And again, so far it looks like the employer does not have to file anything with a DOL or do anything. It's that the employer can deny and retain the records, and that was in section 826.40 of the temporary rule, which we don't know whether or not that's going to change once the final rule is published.
Thanks. A couple of other quick ones in the chat. One is, how should leave time be handled before the April 6th date? I want to just clarify, this kicked in on April 1st. So this one is in effect now. It's not retroactive before April 1st. So if you had people out on leave before that, they don't have to be paid for that. But any of this protected leave, if they fall into these categories, April 1 and on falls into this payment obligation. What if an employee gets sick with COVID while being irresponsible and not following responsible government recommended guidelines? It doesn't make a difference. They're entitled to the leave regardless of how, unfortunately they contracted this. One question is, can we reduce hours and salary for exempt employees meeting the FLSA minimum, which is good, and can they collect for the other portion? If you have an exempt employee who's taking a pay cut, because again, this is something a lot of companies are doing, is just instituting pay cuts across the board for salaried employees, including upper management, generally upper management first, because of the concerns about making sure that this is is not harming people's employees too much. Can they collect unemployment for the other portion? So the answer is maybe. It depends on their comp rate, really. Massachusetts does allow applications for unemployment based on a reduction in pay, but it's possible that these team members might be at a rate of pay that, the portion that they're still earning would outweigh their benefit, which would make them ineligible for unemployment. So it's just a matter of going through the application process and seeing if they qualify. Okay, so why don't we go to some of the questions that we had already received prior to starting. So we talked about the exceptions for firms with fewer than 50. I think we've covered that one. We can move on. So reduced hours. Michelle, do you want to touch on this one?
Yes, so just briefly, if an employee has reduced hours, in other words, if the employer is giving an employee a new schedule based on a reduced number of hours because of the economic impact on the company, that's going to impact the employee's regular rate of pay, right? And how much that employee would be able to be paid during the leave. And that's what employers will need to keep in mind. And again, this may vary depending on whether the employee has been employed for at least 6 months with the company or not.
Taxes. Yes. So the answer is basically yes. You're paying people their rate of pay. It's going to be run through payroll, and will be subject to all the standard withholdings that payroll is typically subject to. So the answer is yes. Does the FFCRA cover time off for the employee's parent in another state who's hospitalized? Yes. So this would be assuming that they're going to care for this person who is ill or who has been quarantined. Then yes, that would fall into that that category of the leave. And what is available to an employee at a small firm if they have a child home now due to daycare closures? So that falls into the 12 weeks, first 2 weeks unpaid, last 10 weeks at 2/3 pay to apply for childcare. Again, unless because of the size here, this firm could qualify for the exemption that Michelle was just discussing. So I think we probably need to move on to the takeaways from this. So I just want to, kind of recap. One thing I want to say, and I've done a number of these, presentations, and Michelle and I both, I think, for the past 3 weeks have done almost nothing but counsel people going through these really, really tough questions, both with, either ill members of their workforce, or complicated leave questions, or more, even maybe more difficult, or some significant layoff issues. And I just have to say how heartened I've been by speaking with our clients in terms of how they are really pulling for their people, really treating this with the seriousness that it deserves, trying to make sure that they're doing everything right in these really difficult times, and looking out for their people as much as they can. So I've been extremely heartened by that, and impressed by the way people are in, the employment community are kind of coming together to try to address these absolutely unprecedented issues. So my takeaway on it is really just try to be methodical in your approach to these leave questions. Make sure, we get questions sometimes that are, okay, well, this is what I did last week. Was that wrong? And sometimes the answer is yes. So take your time, go through it carefully. Obviously, consult, your HR department, your attorneys if you need to, if you have a particularly tricky question. But make sure you sit down with the employee, have good communication, and then just follow the steps the Department of Labor has set out, and you should be fine.
Well, Lindsay and Michelle, thank you so much. And I think the information you've shared has been an incredible wealth of assistance to our community, and we really appreciate all that you've done. And I think that last piece of advice is really the critical piece also, is that we're all going to have specific questions as we're going along, and it's important to get expert advice as we're figuring this out, as well as trying to take care of each other through this. So I want to thank all of you for joining us today, and please share your feedback at communications@architects.org. You can stay up to date on our latest news at the website, through Facebook, LinkedIn, and Twitter, and of course signing up for our e-newsletter that is going to be going out twice a week now on Mondays and Thursdays. We hope that you will join us on Monday at 1 o'clock for our next program, which is a practical guide to CARES Act for architectural firms. This will be this will be followed by another session later in the week as we're working on trying to offer these twice a week. And before I go, I just want to take a moment to thank all my colleagues on staff. As you know, we are working hard to try to bring all of these resources and delivery methods to share with you. And finally, again, please join me in thanking our speakers, Michelle Oliveira and Lindsay Burke. We know that your lives have been turned upside down by this, and as you shared, the work that you're doing has changed greatly, and we truly appreciate your willingness to take time with us to share your knowledge. Thank you for what you do and for doing it so well. And to everyone, a reminder, be safe, be healthy, and be kind. Thank you all.
Thank you.
How do I get off?